Hey folks, Attorney Sharif Silmi. I hope everyone is doing well. I want to sort of jump right in because there are a lot of urgent questions that folks are emailing us and requesting answers to. So today I'm going to cover the area where I've seen so much discussion. And really what we are finding is those of you who have been watching the news closely regarding the current effort to pass a reconciliation bill know that a few days ago, the Senate parliamentarian, and that this is the person designated to determine whether certain provisions of law may be included in a budget reconciliation package, determined that the proposed immigration changes that were being put forward would not be permitted as provided. And for the particular area that I want to cover today, that is a very relevant topic because of the visa backlog of folks who have chargeability related to India. So anyone that's born in India, you know that you're chargeable for that particular country. And what happens is this causes enormous, visa backlog for you and your ability to adjust status. So I just want to quickly run through the adjustment of status bulletin with you. Because again, I think that many folks are a little bit misinformed with regard to the correct information. So I'm pulling that up now. And you can see that this is the actual USCIS page that determines when one may file their adjustment of status. You have to understand that this is different than the State Department bulletin. People are always looking for the State Department bulletin. Now, while USCIS uses the State Department bulletin to determine when adjustment of status takes place, they don't always follow the same dates because the State Department bulletin provides two dates. One is a filing date. So that's the date that one may, if they are outside of the United States, file for a visa. And the other date that the State Department provides is a final action date. So usually or traditionally, USCIS takes the final action date as the date for which one may apply for adjustment of status. However, in this month's or upcoming bulletin for October 2021, which is the first month of the 2022 fiscal year, USCIS has determined that they're going to use the filing date. So that provides a slight advantage to those of you who are, really at the edge. So make sure when you are going in to, determine when you're going to file your I-485 adjustment of status, if you have a previously approved EB3 or EB2 I-140, you want to make sure that the dates that you're looking at are the correct ones. So that is why I want to direct everybody to this page, which is the USCIS Green Card Process and Procedures site, and it provides the visa availability and priority dates. Now, if we look down a little bit here for October 2021, I'm just going to jump right into the employment-based category. The employment-based category for the first category. So the first category includes EB1A, which is individuals of extraordinary ability, EB1B, which is for individuals who are tenure track professors or researchers, and that does require that you work in a research-only position. There's a lot of mistakes where folks file under this EB1B category, and they are actually in a research and development role, an R&D role. And that does not that is often a basis for denials. So you got to make sure that when you submit your EB1B case, you're talking strictly in a research related role for those particularly who work in private companies. Now, we see again that the dates for the first category are current, right? With respect to the second category, the date did jump forward quite a lot from last month. So the final action date for October, the date for which you can adjust status for October is July 8th, 2012. And third category is now at 8th January 2014. 8th January 2014. So what this means is if you have a priority date that is prior to January 2014, then you may adjust status now. And if you are in an EB2 category with a priority date that is before 2014, what you can do is you can file an I-140, or your employer can file an I-140 on your behalf under the EB3 category. Because if you qualified for EB2, then you will, of course, qualify for EB3 because the qualifications are less. So just so you are all aware, the priority, the filing dates right now are based on the adjustment of status bulletin on USCIS website. I would not even waste time going to the State Department bulletin, because that is just going to confuse or provide you with the wrong information. And many people have, used the wrong dates, or maybe not filed because they were looking at final action date when in fact USCIS allowed adjustment, or is allowing adjustment of status for the month of October to be made using the filing date, which again, you can confirm on USCIS website, not on the State Department website. If you are outside of the United States, then you want to look at the State Department bulletin, which will provide a separate list for filing date. That's when you can file for your visa versus the final action date, which is when your visa will actually be issued. So please pay attention to this. This is a huge mistake that many people are making, which either prevents them from being able to undertake certain activity, or they go forward with certain activity that they're not yet allowed to do. So that is just a quick update regarding the visa bulletin, so that you are all aware. So just going back to our topic and reason for our discussion today, we are definitely looking at the idea that we are in a situation right now where there's a lot of conversation, there's a lot of discussion about solutions to the visa backlog, the EB backlog, as it's called, and that is severely impacting folks from India and China. And that is, of course, because only a certain percentage of all visas issued may be reserved for individuals from specific countries, and there's a much larger amount of visas that are applied from people who hail from India and China. So I think we have to just keep paying attention to the developments. There is a plan B that is being worked on presently that will be again submitted to the Senate parliamentarian. So we'll see where that goes. However, I again, want to stress that for us, what we are, able to do is go through your specific roles and status and make sure that we put you in a situation where you are doing everything you can for your family in order to be successful. And right now, what we have been doing, I would say over the past several years, but in particular, throughout 2021, we've had a high level of success in the EB1A category. There have been, a huge amount of approvals that we've been able to get for individuals, particularly those who are in a technology-related field. And I kind of want to explain why. I think I'm going to let out a little bit of trade secrets today so that folks can understand that you have help. You have the ability to, do this if you are in a class of individuals who can qualify. So when we're looking at the EB1A category, the first thing we need to understand is that there's a statute at play. So we have to make sure that we're meeting those statutory requirements, the legal requirements that are underlying the visa. So what happens is Congress passes a law, they have a statute, and then it's up to USCIS to provide regulations and directions about how they're going to implement the law. And when it comes to EB1A in particular, what we are looking at I would say the centerpiece of our EB1A case is that one has made what's called original contributions of major significance to their field of endeavor. So in past discussions, I've gone in really deep about what field of endeavor means and how one may narrow their field of endeavor. And the reason why we want to narrow your field of endeavor is because of this particular requirement where you have to demonstrate an original contribution of major significance to the field. So the way that we're going to structure a case under this criteria is to separate out the requirements. So let's think about them. Original contribution of major significance to the field. So you need to separate originality and significance. What that does is it creates a narrative where on one hand, you demonstrate originality, that I have made an original contribution. Now, the question is, what kind of contribution are we talking about? Because, you know, everything I read online, all of the forums, all of the discussion, when I talk to people about the possibility of filing EB1A, most people are mentioning that, hey, I have to have publications, I have to be a scholar. Well, that is absolutely false. And the reason why I could say that with confidence is because we have to look at the statute. The statute does not say that one makes an original contribution of major significance. It specifies what kind of contribution. So it provides 4 options: that you have made an original business-related contribution, scholarly-related contribution, athletic contribution, or artistic contribution, right? So the scholarly contribution would necessitate that one have a publication and research and citations and all kinds of recognition for that scholarly work. However, the vast majority of folks who are, able right now to apply under EB1A have actually made business-related contributions. And a business-related contribution encompasses technology-related contributions. So if we go to our analysis, what we are really talking about right now are original business-related contributions of major significance to the field. So how do we accomplish this? Well, the first thing that we need to understand is that you have originality, and that can be demonstrated internally from within your organization. You do not need external evidence to prove that you are the original contributor for the particular business contribution that you've made. So I'm just going to use an example I've used in the past, which is where one has, for example, created a new database for the purpose of migrating information from a legacy system to a digital system that is now available and accessible to streamline and make work more efficient. So this new database would be considered an original business-related contribution because prior to the architect designing or creating the database, it did not exist. And we can prove that the individual, the database administrator or software architect, is responsible for creating this database. That may be demonstrated through internal documentation. For example, one may have presented design drawings to their C-suite, or for example, they have a letter confirming that from the organization that owns the intellectual property that this particular database has been created by the individual. That is demonstrating proof of originality. Now, once you have proof of originality, the question becomes, well, if you have proof of originality, the question becomes, what is the evidence of significance and how is that going to prove my case? Well, one thing I can tell you very directly is that once you have proof of originality, you now have the right to claim the contribution. right to claim. So right to claim means that the database is now yours for the purposes of EB1A filing. So all of the evidence that comes under significance will actually be related to that particular database. It does not necessarily have to be about the applicant. So we have to look at what are the factors for significance. How does one demonstrate the significance of their original contribution? So we prove the original contribution through the internal work product documentation, through a letter from the employer or organization for which you have made the contribution. Now we have to determine how is that contribution significant. So I'm gonna relate that to you, but I just wanna first address this question that was brought in. This individual is currently working for a software company that specializes in the healthcare industry. In particular, they're working around the recent COVID-19 pandemic and how software can be used to predict the next geographic surges. I do not hold a PhD or have publications. Do I have a chance to apply for an EB1A? And the answer to that becomes, yes, you do, because if this particular software application that predicts where the next surge is going to come from is yours, you have created it, it has now come into existence, and you can prove that. You don't need a patent. You don't need a scholarly article written about it. What you need is proof that this is your original work, that it did not exist and you brought it into existence, or you're a member of a team that brought it into existence, right? So then we now have originality. However, originality does not mean that you are going to be approved or recognized, because you have to complete the entire requirement. You have an original business related contribution, right? You've created an application that predicts COVID surges in particular geographic areas. How do we demonstrate significance? Well, I find, and this is not written down anywhere in the law, but this is just through many years of experience and practice, there are 4 factors for which significance can be demonstrated. The first way that we demonstrate significance is through what's called impact on subsequent work in the field, meaning that the original contribution that you have made, whether it's a database, whether it's an application that predicts COVID-related information, has it impacted subsequent work? Is it being relied upon by others in your field? Or has it influenced other software architects or product makers in creating their own similar product? Meaning that, look, we have been influenced by your work, by your techniques, by your outcome of your work. This is impact on subsequent work in the field. Now, the thing that you have to understand about impact on subsequent work in the field is that evidence must transcend your employer, okay? You're not going to be able to prove the significance of your contribution from your employer. That is out of the question. It does not matter if you can be at Google, you can be at Intel, it does not matter. You have to demonstrate that your contribution has transcended your employer. It has reached beyond, it has made an impact on subsequent work in your field. Not impact on subsequent work within the company, but within the field. And this is a fundamental requirement. So impact on subsequent work within the field. Now you have to understand this evidence may be solicited. You may request such a letter. I would always suggest that the further away the individual is from you, the more valuable that individual's testimony is regarding the significance of your work and the impact it's had on subsequent work. So for example, you could think of an industry letter. So if one is in a particular field or industry, then the question becomes, what have they done within that industry? What have they done to think about providing this kind of evidence? And really, it's about demonstrating the actual impact it's made on other people's work. The second factor regarding significance is whether the work has received widespread discussion. This, in my view, is the most valuable kind of evidence to prove significance. Let's think about, again, go back to what I mentioned earlier. Originality means that you have right to claim. Originality equals right to claim. So you own this contribution, right? So what is the widespread discussion now available about this contribution? Let's talk about our database, right? So if you created a database for a state agency, and then a newspaper article was released stating, for example, that the Motor Vehicle Association in a particular state has launched a new database that holds all of the driver's information and tickets or driving records, right? And that's published in a newspaper, and it's not talking about the particular individual who created the database. Rather, it's just talking about the database itself. That is sufficient evidence of widespread discussion of the contribution because you already have demonstrated originality. You are the original creator, and you have now right to claim, and it is discussed publicly. Therefore, you are able to demonstrate that you are making a contribution that is significant through its widespread discussion. So this is really a great way to demonstrate that, we are able to prove the significance. So the other individual mentioned that the award-winning entrepreneur in India, 15 newspapers that have written about me. Do I qualify? The jury is out. I mean, we don't know if you qualify or not. What we do know is having media mentions is a criteria among 10 criteria that demonstrates that you have recognition of sustained acclaim in your field. And that is certainly good news for you to have those articles. We have to look at what is the circulation of those newspapers in which you were mentioned, where were they mentioned, who was the author of those articles, what is the credibility of those media outlets, and what other kinds of evidence do you have? So, those are all questions. The fact that you're in India definitely, I would say makes it such that you ought to really pursue this first category EB1A because you're not likely to have a previously approved I-140. Therefore, if you want to apply for a visa, immigrant visa, and enter the United States, really the first category is going to be the best place for you. So I would encourage that individual to reach out in the sense that, we can help you analyze your overall case and make a determination about whether you qualify. So going back to the significance of your contribution, we mentioned impact on subsequent work. We mentioned widespread discussion about your case. The other two areas that I think are relevant are going to be number one, whether the contribution has made an economic impact. What is the economic? Is it measurable? Is there a dollar and cents impact? Do you have license agreements between your organization and customers or other parties for the technology that you have created, for the contribution that you have made? Is there, for example, internal documentation regarding sales information? Has it been mentioned in an annual or quarterly report by the organization as something that is, fundamentally important and, of interest to folks beyond the company itself? These are all important questions regarding economic impact. The fourth factor that I think is relevant to significance is government interest. Is there public interest with regard to the contribution that you have made? This could be local, it could be state, it could be federal. So if, for example, your contribution is state agency's database, then that in fact invokes a government interest factor that can be used to demonstrate significance. So these are just some techniques, some ways in which you can demonstrate the significance of your work. So again, prove originality first, or if you will, look at the work that you've been involved in, determine what among the work that you've been involved in, what has evidence of impact on subsequent work. What has been mentioned outside of the employment, like widespread discussion? Are there news articles? Are there blog posts? Is there something in Wired magazine? Have there been reviews done about the product? This is what impact on subsequent work and widespread discussion is all about. And then what you could do is the way in which the contribution is discussed and mentioned externally, you can reverse engineer the description of the contribution into your originality evidence. This way, the originality evidence matches with the significance evidence, and we are able to connect the dots such that you may be able to demonstrate this very, very important criteria. Moreover, what happens when you're able to demonstrate an original contribution of major significance to your field, and you've done that in your course of employment? This is important and huge evidence with respect to performing a critical role for an organization. And the reason for that is because the requirement of critical role, performing in a critical role, is that you have made an impact on the outcome of the organization's activities. So if your contribution, which was made in the scope of employment, your business-related contribution, is deemed significant to the field, well, then it will definitely be significant to the outcome of the organization's activity. That is a lower threshold, because here it only needs to be significant to your employer. So what happens is when you make a very strong argument under original business-related contribution of major significance to your field, that even if you don't meet that criteria, what's going to happen is that's going to give you a huge evidence to go through under your performing in a critical role analysis. And note that the regulations state that evidence that is relevant to one criteria may also be relevant to another criteria. Therefore, the same evidence, the same exact documentation that you are putting forward as probative or important and relevant to your original contribution of major significance is also relevant and important to your critical role analysis. So that is very, very important for you to understand, so that you may put yourself in a very strong position to succeed with your EB1A analysis. Because any of you out there that are in a technology related field, you have to understand your foundation of your case is not going to be a publication. It's not going to be membership in a professional organization. The foundation of your case is going to be original business related, technology related contribution of major significance to the field and performance in a critical role for an organization of distinguished reputation. The reason why these are foundational, because just be thoughtful, be logical. That is what you've spent your lifetime working on. Nobody that is working in IT is sitting there writing publications day and night. That's just ridiculous. What you're actually doing is creating technology-related contributions that are being deployed and benefiting society. So those are the contributions that are going to demonstrate that you have not only the quantitative requirements, which are original business-related contribution of major significance to the field of endeavor, performance in a critical role for an organization of distinguished reputation, but it also gives you the qualitative requirement to demonstrate that you are among the foremost experts within your field of endeavor. And once you have those two in the bag, then we can look at whether have you published an article, do you command a high salary in relation to your peers in the field? Are you a member of a professional organization that requires outstanding achievement of its members? Have you reviewed and judged the work of others in the same or similar field? Do you have a lesser nationally recognized awards, et cetera, and so forth? So that is, I hope shedding some light on how you can succeed within the EB1A category for those of you who are actually involved in business technology related contributions. I hope you found this information informative, and we look forward to hearing from all of you regarding your comments, and look forward to working with you.